Hi everyone, welcome to our COVID-19 7 April webinar. I am just going to wait a couple of minutes for some participants to jump on. We've had quite a few registrations and I can see now the numbers are creeping up. So just give it a couple of moments and then we'll commence. For those of you that don't know, Prime Minister Morrison was just doing an announcement post-Cabinet this afternoon on proposed changes to landlord tenant commercial arrangements, and he provided a little bit of information that was somewhat helpful to us. So we have been watching that presentation and I'll touch on that later in the presentation, but that's literally just going to press as we speak, those developments in that area. So definitely we will be touching on landlord and tenant commercial positions in this presentation. Okay, so there's quite a few of you now joined and I can see that it's 2:32, so I'm going to kick off with content. Now, just firstly as a preliminary note, we're not going over old ground in this presentation, so all of our slides from previous webinars are hosted online, and if you need information on basic topics or historical topics like what is lockdown, what can you do with an employee where you can't afford to pay them in terms of stand down and that kind of thing. We have covered that in previous weeks and I don't intend to cover it in detail because there's too much to go through. So have a look at our previous slides for any of those headline topics, but certainly at the end of this presentation, I will take some questions. So if you've got any burning issues we haven't answered previously, let me know. But really today is about updating you on most recent government stimulus, commenting on the JobKeeper stimulus in particular, because that's something that people are a little bit confused about, and talking to you more about landlord and tenants, as I mentioned, and also for those of you who are experiencing financial difficulty, which you feel might not be temporary, we're going to talk briefly about insolvency options for you. And then as mentioned at the end, any questions or answers, any questions that you might have, I'll try my best to answer, and that can be on any topic that we've covered related to COVID-19 over the previous weeks. A little bit of a disclaimer, a bit of housekeeping at the start. Again, this is general information. It may not be perfect for your circumstances, and the situation with COVID is changing rapidly. So by all means, if you have questions, direct them to us by email if they're more complex, and we'd be happy to help. And just keep in mind it's high level advice. So I'm going to cover again, we've touched on this briefly, but the stimulus that you may be eligible for as a business or individual. Again, there are smaller packages that are more personal that are out there, particularly for individuals, but certainly the stimulus listed on this page are the main federal government measures that you might be able to access. So Coronavirus Supplement A, it's a $750 cash stimulant for people on Social Security effectively. It's a one-off lump sum payment. Supplement B is a payment of $550 for people who are on JobSeeker, youth allowance, parenting payment, those existing government allowances, and they've relaxed the eligibility criteria for those allowances. So those of you who have lost your jobs in the past, so that were unemployed prior to 1 March, or who are eligible for those other government's payments, you will find that your payment has increased and there is greater access to this payment. Again, there's another $750 household payment for certain other households that aren't getting the increased job seeker payment. There's also early access to superannuation to $10,000 withdrawals for eligible persons, and this applies to sole traders and casuals who have had an income decrease as well. Just be mindful if you are accessing your super early that this is really a measure of last resort. Super is there for a reason. It's there to support you through retirement, and there's also, potentially some tax consequences or impacts on you later in life for accessing your super. So that should definitely be something of last resort, but it is available for those that really need it. And you need to talk to your super fund and look at the government website before you go down that path. Other measures at a federal level, you're probably quite familiar with these by now. Instant asset write-off. So previously, if you purchased assets, you could have a tax deduction, which was around $30,000. That's now been increased to $150,000 up to 30 June. So that enables businesses who are purchasing assets up to $150,000 or more potentially, but to have access to the $150,000 component as a tax deduction. There are two other payments on the slide, which are employer cash flow A and B, which are additional payments that employers can access depending on turnover. They affect PAYG and are going to help with cash flow. So payments in April to be made, and then monthly payments following thereafter, depending on what you got in April. So those payments are quite well known by now. And probably the most interesting payment that's getting the most attention at the moment is the JobKeeper payment, which was in the third round of government stimulus. Many of you will know basically what that entails, but if you don't, it's outlined on the screen. And basically, it's $1,500 per fortnight per employee, paid to employers for up to 6 months. And basically, what will happen is the government will look at the number of employees that you had employed at 1 March, and that includes employees that have since been stood down, made redundant. They will be counted, and they will calculate those employees based on part-time and full-time employees and casuals who have worked for you for more than 12 months. So they are generally what an eligible employee looks like. And in terms of what businesses will be able to access the JobKeeper, it's businesses that have had a downturn in their revenue of 30% or more. And that's for businesses with turnover up to $1 billion. I assume most of you in here in this webinar are within that category. If you're a business that turns over more than $1 billion, then you're looking at a 50% revenue decrease in order to be eligible. So I'm going to talk about later on what that means, a 30% decrease in revenue, because that's causing a lot of confusion amongst businesses. And I will provide some answers to what I expect will be the most common questions on that topic. Also, it's important to note that the payment isn't going to be made until the first week of May, but it's backdated. So it's going to be backdated to cover March, but you won't get the payment from the government until May. You do need to register for JobKeeper. It's not something that just happens instantly or without intervention. You actually have to apply on the ATO website to be eligible, and then you will be contacted by the government to assess your eligibility. In terms of foreign workers, you need to be either an Australian citizen, have a permanent visa, a special category visa holder, and you must be registered for tax. I can see some questions and answers popping up. I'm going to save them until the end because there's quite a number of them, and hopefully I cover what you're going to ask me in your Q&A, but if not, I'll get to them at the end if that's okay. I can also see some of them are the same questions being asked, so that's good. I'll come back to those. The SME guarantee scheme, so that assists with small business loans. So again, it helps with the write-off of some of those loans. There's also a bunch of stimulus measures there that we've talked about before that are designed to assist businesses that might otherwise be technically classified as insolvent, or these measures are designed to prevent you from becoming insolvent. And these measures are basically stat demand sums. So previously you could issue a statutory demand on a company, which if unpaid and if validly issued could result in the company being wound up. Now, in order to do that, the sum has increased from 2,000 to 20,000. So obviously that gives businesses under pressure some time to manage their debts. Again, the compliance period. So previously you had 21 days to comply with a statutory demand or your company could be wound up. You've now got 6 months. So we're seeing an increased threshold and more time. And that's designed to stop stop businesses becoming insolvent during this time where they are experiencing cash flow challenges. Again, 6-month relief period for personal liability for companies trading whilst insolvent. I am going to talk about insolvency in more detail later, and I will point out at that time that if you are a director, you can be personally liable where your company trades insolvent. what the government's trying to do under this measure is give you some time to try and ride out the coronavirus impact and to access different stimulus payments and to try and see if there is a way forward for you, rather than what would normally be the expectation of immediate action by directors. That doesn't mean you can just sit there and do nothing for 6 months, but it gives you some comfort to try and work on the best strategy for your business during this time. Again, the ATO is looking at ways that it can work with people who have ATO debts. So they're going to withhold or delay winding up companies or director penalty notices where they can, and certainly work with people on tax payment plans wherever possible. Again, personal bankruptcy notices have increased from 5,000 to 20,000. Same sort of purpose, to try and relieve the burden on individuals, give them more time to write their finances and get things in order, if possible. If not possible, then okay, there's still the same bankruptcy and insolvency options are available. But the idea being is to not force you to take action at this time where you'd otherwise be okay. In addition to federal government measures, again, I'll come back to JobKeeper later. I know that there's burning questions on that, but there are a number of state-based stimulus payments depending on when you are. I won't go through them in detail, but I will comment on the highlighted one at the top, which is a popular one for New South Wales, which is a small business grant of up to $10,000. I'm going to get into that in more detail because I think that is an interesting and important one for a lot of businesses, particularly those in hospitality and retail that have been severely impacted or closed, or gyms. So we'll get onto those small business grants shortly, because I know many of you want to apply for them or have applied for them or thinking about applying for them. So I'll touch on those shortly. But then by all means, go through and have a look at each state's individual state measures and familiarise yourselves using the links there to the extent that they apply to you. Most of you will be probably New South Wales or Vic, but certainly we've expanded on the other states there. Again, Overpage has ACT and Tasmania. Okay, back to everyone's favourite topic, the JobKeeper payment. In summary, again, $1,500 per fortnight per employee for full-time, part-time workers and casuals who have worked for you for 12 months. So that's not casuals who have just worked for a number of different businesses for 12 months. It's where they've worked for your business for 12 months. I will cover off later what happens if someone has a multiple number of casual jobs and how they go about being eligible. It looks at who was employed in your business as at 1 March. So even if the employee has been stood down since then, if at 1 March they were employed by you, then they will be eligible provided the business is eligible. The payment will be calculated from 30 March and paid in May. So what that means, and I know that's concerning for some people, is that there is a delay in payment, and the JobKeeper payment is a reimbursement payment. It's designed to be a supplement, not to remove the obligation of an employer to make a payment. So employers are expected to pay their employees and then to be reimbursed from the government for that period. And I know that some of you asking questions right now will be asking, well, what if I don't have the money to pay that? I'll cover what happens with that later. But that's generally the payment period. So employed at 1 March, it'll be calculated at 30 March and paid in May. The payment period is intended at this stage to go for 6 months. So that gives you some, I guess, guidance on how long the government predicts that the impact of COVID-19 will be applying for. If you have implemented the ATO single touch payroll system into your business, excellent, great. That will now enable the government to easily determine who your employees are as at 1 March. If you haven't, that's still fine. It's just more of a manual application process. For those of you just joining and asking questions, I will tackle them all at the end because there's a lot of duplication in the questions, and I think I'm going to probably answer most of them by the time I get to the end. So hang in there. The JobKeeper payment applies in addition to normal income. So if you're a person who earns $100,000 a year, the way that this works is the payment goes to your employer to help cover some of the cost of your wage, so up to $1,500 a fortnight. It's not as though you get less money from your $100,000 salary and the government chips in $1,500 to you. That's not how it works. You get paid as you normally do, and this money goes to your employer. It's not that you also get a windfall and get an extra $1,500 a fortnight. Again, that's not how it works. It's a supplement. So if you earn less than $1,500, you'll be topped up to $1,500. If you earn more, then the payment goes to your employer to help cover your wage during this time. Self-employed people can claim the JobKeeper payment as well. As mentioned before, you do need to register. There is a link there to register. The number of businesses that are registered is skyrocketing, so you're not alone if you do register. You need to be an Australian citizen, have a permanent visa or one of the visas listed on this page, and be a resident for Australian tax purposes as well. If you are on parental leave at the moment, being a paid parental leave from the government, you're not eligible for the JobKeeper payment. But if you're on paid parental leave from your employer's voluntary scheme, then you will be eligible as though you are working at the moment. Business eligibility, this is a bit of a burning issue for people. And I must say from the outset, there's still a lot of clarification needed from government on this, and we didn't see that clarification today. In this Prime Minister Morrison's address, he didn't touch on this eligibility. What we do know is that your turnover must have fallen by 30% or more. Again, if you've got a business with turnover of more than $1 billion, then you're looking at a 50% decrease. Charities or not-for-profits only need to show a 15% downturn in revenue. What is revenue? This is the thing that's posing a bunch of concern for people. So basically, you're looking at the same time last year, either the same month of March last year or the same corresponding BAS quarter. So however you normally pay and remit your BAS for this period, you need to look at the same period last year and assess whether you've had a 30% decline in revenue. Now, many of our clients are contacting us and saying, I don't think I can satisfy this 30% comparison. You know, my business is a new business. It wasn't trading last year. I have really unpredictable revenue that goes up and down. It's seasonal. This time last year wasn't relevant because X, Y, Z had happened. We were closed. Our business was, you know, subjected to a flood or whatever it might be. Or we had a merger with another business since then and things have changed, or we sold off some of our business, so we might not be down on last year. Or a really, really common one is we're a rapidly growing business, and year on year, our business revenue goes up by, let's say, 100% on last year. Now, you may not be down on last year, but since that time, you've employed 10 more people, leased a bigger premises, bought bigger plant and equipment. And when you look at last month or the month before, you might be down 100%, 90%, 80%, 70%, whatever it is. But this time last year, when you were in growth and build phase, you might not be down on that number. The government has made it clear that the intention is to be more generous than not with this JobKeeper package. It's to keep people employed. So the Commissioner has a whole bunch of discretionary powers to enable people to access this JobKeeper payment, even if they may not technically fit the this time last year test. There will be alternative eligibility tests that will be announced shortly. And also a discretionary power, despite everything, to look at the evidence and determine whether there has been a significant downturn. Certainly, I know a number of clients that I've spoken to in the recent days have really felt that they're not going to be eligible on the current payments because of that ramp up in business or significant changes in their business since this time last year. But they know that based on the last couple of months or even the last quarter, their business has been severely impacted. So the likelihood is that you will be eligible. We just don't know how you'll demonstrate that yet or what alternative options there are. But again, that discretionary power is there. Frequently asked questions. So these are the questions that people have asked us consistently throughout this week. I've got employees with multiple jobs. Typically, they will be casual jobs or part-time employees. How do they demonstrate eligibility? The employee is required to notify their employer that they consider them to be the primary employer. So if an employee notifies you that you are their primary employer, then they should be included in your communications with the ATO seeking this JobKeeper payment. Again, keeping in mind, it is your obligation as the employer to liaise with employees about this scheme. And if you and to discuss it with them so that you can capture this type of information. Don't have single touch payroll. Again, you can still claim, but just more of a manual process. So currently what happens if you haven't already registered on the ATO website, go on, click the link, put in some very basic details, your ABN, company name, tick a box, and what will happen is it says that they will be in contact with you, they being the ATO, when they wade through the hundreds of thousands of registrations that they've got there, and they will then ask you to supply information. What happens if the employee normally earns less than $1,500? So if you've got an employee who earns much less than $1,500, you need to top them up to the $1,500 in order to be eligible for that payment. So I'm not sure if that makes sense, but if they're regularly earning $800 or let's say $1,000, you need to top them up to $1,500 in order to get that full amount back. So there's obviously no harm for the employer in doing that, but it's just a cash flow issue. Is payment made to employee or employer? No, it's made to the employer, not to the employee, and it's designed to supplement or reimburse for money already paid. What happens until May? Basically, as an employer, you're expected to make payment of wages as normal and then claim the reimbursement when it's paid to you. I think that's going to pose a bit of a concern for some people who don't have the money to pay employees, particularly those that have been stood down. What the government is saying at this time is to speak to your banks. Banks are indicating that they will consider the eligibility for JobKeeper when deciding to grant temporary loans or credit. So you might find that your bank will lend you the money to cover your wages for eligible employees up until the government pays the payment in May to enable you to access this and to comply with their payment obligation. But certainly you are expected to make payment as normal. What about if your turnover hasn't dropped by 30% yet, but you think it will be? You can apply now if you anticipate that in a very short period it's going to hit the 30%. So if you're close to 30%, if you're not there yet, but you can see that it's going to happen, let's say in June, apply in June. So it'll still be open for application until that time. Don't apply if you don't need it, obviously, but if you can see that it's going to happen, keep an eye on it and apply at that point in time. Superannuation, how will this impact super? It won't really. Your super will be paid on the normal wage. It won't be on any JobKeeper component. So it's not going to impact super at all. What about directors and shareholders? So your company can nominate one director. I'm talking about directors that get paid for board positions, and one shareholder per company to receive JobKeeper. So we can't have a company with 100 directors all claiming this to supplement their directors' fees. Can I require employees to do more work to make up the value? Well, I think that question is a misunderstanding in some way of what JobKeeper is meant to be. It's meant to maintain people in their current jobs. It's not meant as a manipulation of current working conditions. It's meant to reimburse an employer or to supplement the wages that the employer is making. It's not designed to create new employment per se. But if you've already stood down an employee or reduced their hours, and you now feel that you, with the assistance of the JobKeeper, can afford to get them back in the workforce where they've been stood down, or you could make use of them in the workplace still, and that this payment will allow you to get them back in and to doing more hours, by all means, yes, definitely. If they've been stood down, there are ways in which that can be reversed, and they can be required to return to work, particularly now that they're going to be receiving some pay. Again, it doesn't mean that you can require someone to return to a full-time role in exchange for their $1,500 if that's significantly less than what they were doing. But certainly if they are going to be receiving income now because of the JobKeeper pay where they weren't ordinarily or weren't before, then it's reasonable for them to be required to do some work. So I'm thinking here of an example of someone who might have a cafe and or a restaurant and has had to close, or a gym and stand down their workers. Where there is work that could be done from home remotely, for example, that needs to be done, and workers are now going to be receiving a payment from their employer because the employer is getting paid, then it's reasonable that those employees are asked to do some duties from home if there's something that they can actually do, given that they will be now receiving a payment. That doesn't mean, as I've said, that they can be expected to do 38-hour working weeks from home on things that aren't necessarily necessary to be done, but certainly if they've been stood down and now they're going to be receiving a payment due to the JobKeeper assistance, then yes, it's reasonable. The government has announced today that they will be making changes to the Fair Work Act to actually allow employees and employers to more easily vary hours, roles and places of work to tackle the COVID-19 impact. So we don't know what that means, other than it's likely that employers will have more powers shortly to require employees to reduce their hours. Or so, for example, it might be that an employer can require an employee to work 3 days instead of 5 in order to assist with the cash flow. Whereas at the moment, those sort of changes require mutual consent. It is likely that the Fair Work Act will be amended to give employers more discretionary power where they need it because of COVID. So hopefully those FAQs have answered most of them. Again, I will answer your burning issues at the end. I do want to talk about the small business grants because they're really important, and we're getting sort of an email a day on these. So there's a small business support fund where you can access a grant of up to $10,000 and you apply via the Service New South Wales website. Last time I checked, that wasn't live, but it hopefully should be live very shortly if it isn't already today. You can apply until 1 June 2020. And if you're eligible, your business will be a business with between 1 and 19 employees and a turnover of more than 75,000. So you're registered for GST. A payroll in the 19 to 20 financial year payroll tax threshold of 900,000. You must have an ABN, be based in New South Wales and employ staff at 1 March. And you must be highly impacted by the public health COVID-19 restrictions on gathering and movement order 2020. So I'm thinking there about, it's obviously hospitality venues, it's gyms, it's beauty salons, it could be hairdressing salons as well. Anyone who has been severely or highly impacted by those closures and those restrictions need to apply if this is something you want to access. We're thinking and we believe that you'll need to demonstrate a revenue loss of probably more than 60% to be eligible. The purpose of the funding is to be used to help with unavoidable costs such as utilities, overheads, legal costs, financial advice, whatever it is that you need to navigate through this time. That's why they're provided. That's what the grants are intended for. I'll just have a quick look at any of these. Commercial tenants. Sorry, someone's just asked a question about, which I will answer now, about the revenue test. Is it a reduction of profit? I thought it was revenue. It is revenue. If I've said profit, that's just me speaking off cuff. It's definitely revenue. So ignore that. I'm just checking the rest of them. Something I've already missed. Yeah, okay, so a lot of them are going to be covered, or I'll get to at the end. All of these are quite specific. So I'll come back to those questions shortly. I'll work out how to close out of this. Okay, so I've touched on the small grants. I'm going to talk quickly on the landlord and tenant relationship, keeping in mind that literally 40 minutes ago, Scott Morrison came out with an update on this, but in my opinion, he didn't really provide much of an update on what we already knew or anticipated him to say. Basically, there's going to be a code which is currently being finalised and will be implemented by each state, which will set out what is expected of landlords and tenants in respect of commercial leases. So that includes retail leases. Basically, what's going to be expected of landlords is that they provide assistance to a tenant proportionate to whatever the decline in revenue is of the tenant. So it's expected that if a tenant's revenue has gone down by 50%, that the landlord will work with the tenant to provide assistance equal to 50% of their ordinary rent. Now, that doesn't necessarily mean that 50% of your rent will be waived forever. It's likely that that will be provided in the form of abatement and deferral. How that is going to play out, we don't know. For those of you that don't know the difference, abatement does sort of mean that the rent is reduced and that's all you have to pay, whereas a deferral means that the rent's still payable in full, but your obligation to pay it is delayed. So for example, if your monthly rent is $10,000, if I say to you that $5,000 is deferred, it simply means that $5,000 is payable now and $5,000 is payable later. Later could be in 6 months' time in a lump sum, or it could be most likely that after the abatement deferral period ceases and things go back to normal, that $5,000 saving is added to your rent incrementally. That's kind of the approach that we expect to see. But what is encouraged by the government is a combination of abatement and deferral. So waiving some entirely and postponing some. Again, we don't exactly know what is expected in terms of how much abatement, how much deferral, but we know it should be proportionate and it should be abated and or deferred in some sort of package. Again, landlords and tenants are expected to negotiate and work together on an arrangement that is viable. I won't say that works for everybody, because it simply won't work for everybody, but that's the expectation. One other thing that Prime Minister Morrison noted is that the code is expected to only apply to businesses with turnover of $50 million or less. So it may not be the case that the code applies to extremely large retailers, national retailers, but again, I've only going on Mr. Morrison's live address an hour ago. We need some more detail on who will be captured by the code. In terms of extending leases, it is expected that the code will allow landlords to extend a lease duration in order to capture the closure period. So if, again, my business shuts for 3 months as part of the government requirements, or I've shut it because it's simply no longer possible for me to trade, it is expected that the code will allow the landlord to increase the duration of the lease by the same period in order to, I guess, capture the rent that they've missed out on, and to also, from a tenant's perspective, allow you the same benefit of trade at a later date. We are seeing amongst our landlord clients a desire to extend leases, particularly where leases are due to expire in a short period or where you're in overholding. Logically, it seems unfair for a landlord to provide relief for tenants if the tenant is out of term or their lease is about to expire, because they may not know whether they're going to get the money back. And so we are expecting that the code will have provisions enabling an extension of lease to ensure that deferred rent can be repaid and that tenants have time to trade when things get back to normal. Moratorium on evictions. Again, we've heard about the 6-month moratorium on evictions, stopping landlords for evicting tenants for the next 6 months or so. Again, that doesn't mean that a tenant just ignores the landlord and buries their head in the sand. The obligation is for the parties to communicate and reach a resolution as soon as possible. But in saying that, landlords are not expected to evict tenants who are in financial difficulty due to COVID-19. Businesses that aren't impacted by COVID or are trading well, lucky them, there is expected to be no variance to their lease terms. It's not a situation that just because other traders are getting access to support that you can too, to make it a level playing field. It's not what the government anticipates happening. It's really only for those people that need it. Otherwise, you're expected to comply with your lease as normal. Residential tenancies weren't discussed by Prime Minister Morrison today. Again, we expect similar legislation or codes to be released shortly by the states dealing with residential tenancies and providing more information on right of eviction, which, as we currently know, the Prime Minister has said he expects that tenants don't get evicted, and that's a really important thing, but we don't really know what is required by landlords at this point in terms of residential rent. One other thing to note is that Queensland has already introduced a COVID-19 rental grant. It's a 4-week rental grant paid to the landlord where the tenant is distressed or unable to pay rent. So to my knowledge, that's the first state to introduce something like that. And if you are in Queensland or have tenants in Queensland, this is something you should definitely look into. And that's residential. This was a slide that we featured last week, talking about the Australian Banking Association's response for what they're doing with loans for businesses, a business loan. So this gives some information on if you have a loan, what you can do when you're talking to your bank and what's expected of banks in terms of their relief that they're offering to businesses. So have a look at that slide. Likewise, if you are an individual with a mortgage and you are suffering financial difficulty, most of the Big Four and in fact second tier lenders will have links on their website where you can apply for mortgage relief. And I think that's basically in the form of a holiday whereby you aren't expected to repay your mortgage for a period of 6 months' time, but those payments that you should have made will be capitalised into the loan. So you will pay them eventually, but there is a relief period there for those that have been impacted. And my understanding is that the test is quite generous, so you simply self-assess as needing assistance, and I believe that it's kind of acting on a good faith, I guess, assessment at this point in time. So you provide some basic information and you should be able to access that. Before I get to questions, I'm going to touch on, I guess, an unhappy slide to finish off with, insolvency. So that's one industry where we do expect there to be a lot of movement in the coming months, which is insolvency. So whilst there has been government attempts to reduce insolvencies due to COVID-19, the reality is if a business was already in trouble or struggling before this, despite the stimulus, it might be that they find they cannot simply go forward. That this, I guess, brings their conclusion forward in some ways. The measures the government announced in terms of insolvency were more designed to assist businesses that were ordinarily doing okay, where this has sort of come out of left field and wiped them to the ground. So if you are already facing financial difficulty and the stimulus measures are not enough, it's simply a case that you don't feel that you can pay your debts when they fall due despite all of these stimulus measures. So if you can see that at the end of the next 6 months or so, even with all this assistance, you're not going to be able to get out of this situation that you find yourselves in, then you need to look at your obligations in respect of your company from an insolvency perspective. So company directors and officers have obligations under the Corporations Act, and that is that you should not be trading if you are insolvent. Again, there's that 6-month grace period we see for coronavirus, but you will know, or you should know, whether that 6 months is really just delaying the inevitable and whether you should start to think about action now. There are some debts which, if you don't pay them, become the personal responsibility of directors and officers. I'm talking about superannuation, some business taxes, PAYG, and as of 1st of April, GST. So please, if you think you are in trouble, don't just use the hibernation period to do nothing. Use this time to be proactive and to try and think about, okay, what can I access? How can I try and support myself through this time? And if I can't, what am I going to do? Because it's really important that you work out whether it's just short-term cash flow or whether there's a long-term issue. If you are experiencing short-term cash flow challenges, first of all, talk to your advisors, try and see if you can negotiate payment plans with the ATO, with your suppliers, whether there's debt that you can access to get you through short-term cash measures. If there's long-term issues that can't be immediately resolved, then the options are really, I guess, administration of your business or liquidation. It is possible for a business to go through an administration process and to come back out of it. So it doesn't always mean that, you know, that it's all over for your business. There are options. Keep in mind, if you don't do something and you don't pay your business debts, then leaving aside the COVID-19 measures, a creditor can seek to wind up your company or appoint a receiver. So if you think that that's something that might happen to you, then you need to sort of get in there first and take some steps. Again, these are business measures, but for individuals, if you feel experiencing hardship and debt, and despite everything you feel like you're not going to get through it, then please speak to somebody. Don't let it go on longer than it needs to. That's kind of what we wanted to tackle today in terms of content. Again, we're going to be actively monitoring the government's position on retail and commercial leases, because that's going to become something that really affects us all in the coming week. Likewise, we'll keep an eye on stimulus. I'm going to have a look now at these Q&As and see if I can answer some of these as I go. Can I please explain the commercial tenants plan? Hopefully I've already answered that. So again, commercial tenants at this point should be talking to their landlords and asking for rental relief or abatement equal to the loss in revenue that they're experiencing. So to do that, you would need to demonstrate that loss. I would expect that you would probably want to look at the same approach as the JobKeeper approach, which is showing a 30% or more decline in revenue against last year, showing your landlord that you have suffered this declining revenue, and asking them to come up with a package with you that comprises abatement and deferral of the same amount. And also talk to them proactively about what you're doing to try and help your business. So please don't come to your landlord and just simply tell them you're in distress and ask for a handout without being collaborative. So you're more likely to get a result from a landlord if you engage with them positively, show them the steps that you've taken, show them that you were a restaurant who tried to do takeaway, but despite that, it's just not working. Tell them that you've had to stand down your workforce, explain to them, work with them, you'll get a better result. That's definitely what we're seeing with our tenants and our landlord clients, is the more information and the more consultation, the better the outcome. And the outcomes are varying drastically amongst landlords and tenants. So try and put your best answer or your best position forward. Again, someone queried my use of the word profit. It should be a reduction in revenue of 30% or more in order to access JobKeeper. So sorry if I mentioned profit. Does it cover March? So again, it looks at who was employed in March, but my understanding is the calculation is from a date later in March. I think it's 30 March or 29 March. Paid in May. So from March, the end of March until May will be backdated into May. Are there any stimulus measures to help business owners who aren't employees who draw on company profits, dividends for personal income? I don't think we qualify. Yes, there is. So I mentioned that before. There is directors and shareholders have one per company have the ability to draw on JobKeeper. So again, you'll have to provide supporting evidence, but that has been recently answered in a Q&A by the government, but we await more detail on what's required. But the answer is yes, where that is your regular income, it's likely that you should be able to. Do full-time people have to work for 12 months? No, no, that's just for casuals. So if you've got casuals, they have to have been working for you for 12 months. Other people, it's just who was employed as at 1 March. Are you able to provide copies of these slides? Yes, definitely. You can email us, or we will put a link on our website to these slides and we'll host them all there. They're also available to watch these videos on YouTube, but definitely contact us via email or go onto our website. We'll update them in the next day or so. Does the employer pay the difference of the wages per employee? So basically what happens is if I normally earn $1,500 a fortnight, then the employer pays me $1,500 a fortnight and then gets reimbursed that. If I normally earn $2,000 in a fortnight, then the employer still pays the $2,000 and gets $1,500. The employer must pay the $500 that they would normally pay, the shortfall, I guess, from the payment. Working directors not drawing a salary. Again, you do need to submit evidence that you are a director who does have drawings. That can be director's fees or otherwise. In terms of what that evidence looks like, where you're drawing fees periodically or sporadically, you should still have evidence in terms of your personal income and assessment. So I think you'll be relying on on the ATO's discretionary powers, but you should be able to demonstrate a reduction in this time last year or this period last year, or fall within one of the exemptions for people that have unpredictable income. So the answer is it is intended to capture at least one director per company, but it's unclear as to what you'll have to provide. What if a 12-month casual employee resigns due to COVID, fear or other reason, even though there was work, and they receive $500 a fortnight? Do they now receive the full JobKeeper? So firstly, if they have resigned since 1 March, that's okay. They'll still be eligible for the payment, even though they resigned due to fear and there was work. They receive $500 a fortnight, and then they receive the full job seeker. So they will receive the full job seeker. If you pay them the $1,500, then the employer will be reimbursed that. The fact that they've resigned, it's kind of irrelevant for this purpose. If they were employed at 1 March, it doesn't really matter whether they've resigned or not. Good question. And I don't know the answer to this immediately, but I will find out. Is the $1,500 gross inclusive of PAYG or net exclusive of PAYG? I'm going to hazard a guess and say it's not taxed. I think it doesn't work that way. I think it's a reimbursement to the employer. I don't think it's about the PAYG, but I would assume that it's net, but I'll have to clarify that. Good question. What about tenants who are already behind on their rent before COVID-19? Can we still kick them out? Interesting one. So COVID-19, this rental relief package is not there to save bad tenants or tenants that are already in distress. And certainly a lot of landlords that I've seen at the moment have said to tenants, I'm happy to give you some relief through this period, but I need you to pay the rent that you're behind on. And that is on the basis that that behind rent was pre-COVID-19. The reality is, if they're in distress now and they were having trouble before paying their rent, there's almost certainly no chance they will be able to pay that rent. So in some ways it becomes a nonsense. Can we kick them out? If I think Mr. Morrison would be here, he'd say, no, you shouldn't. That's not in the spirit of what the plan proposes. It's to assist all businesses. But at the end of the day, we need to wait for those guidelines and that code to come out later this week to see if it deals with tenants that are already in default. But certainly landlords, from my perspective, should be pushing for those defaults to be remedied before they come to the party with relief. Whether that is, look, I'm going to give you relief, but I need it to factor in some of those arrears that you've got. So if you owe $10,000, I'm going to give you some abatement, but we need to come to an agreement on when you're going to pay that $10,000 back and how. And perhaps that's factored into their plan moving forward, that $10,000 of arrears is paid back in addition to some of the deferred rent. If the tenant doesn't hit the 30% required for JobKeeper, does that mean no reduction at all? Interesting question. We don't know the answer to that yet, other than the Prime Minister has said that the JobKeeper eligibility should be used by a landlord to determine whether a tenant has suffered a downturn in revenue, but it hasn't been confirmed that that's a conclusive requirement at this point in time. So most of our landlord clients are still negotiating with tenants at this point in time because they don't know whether they're eligible for JobKeeper. They haven't been confirmed yet. They might have applied for it. They don't know, but they're still working with them on it. So my understanding is that's a litmus test and certainly something that should be looked at. And maybe the code will have more clarification on that. But I think even if they don't quite hit the JobKeeper, if they can demonstrate downturn, I suspect the expectation is that landlords still work to find a solution. But again, subject to what the code says on that point. Has there been mention of tenants being able to terminate their lease early due to financial distress? Yeah, it has been raised and we expect it to be dealt with in the code, hopefully. But certainly there has been, where a tenant is forced to close their business entirely, whether they're in one of the stage 1 or so lockdown restrictions, that there has been a suggestion that landlords should work with tenants to potentially allow them early termination where there is no ability to trade. But again, that should be something that is addressed in the code released by the government. But definitely it has been contemplated that landlords and tenants should be considering that as an option. In some circumstances, certainly not across the board. What about agents' fees? Our fees will be reduced as tenants are not paying. Do we get a government subsidy? That's a really good point for those of you that are relying on rental fees to be paid, and that's your income. So if you're an agent and your business is not generating the same amount of income, then I don't see why you can't access the JobKeeper payments to help you with your wages, or other sort of government stimulus that we've talked about in this presentation. You are like any other business, but there hasn't been a specific announcement about what happens with agents' fees. It's certainly on the mention and something that governments are aware of because I've seen it covered in media. But let's see what comes out of the code. But I guess the short answer is you're a business, so you have access to all the other stimulus that other businesses have. I'm getting questions on the accounting treatment of revenue as to whether it can be on EBITDA than revenue. Again, I'm not going to get too much into that detail because we need that clarification to be confirmed from the government. There are some Treasury papers that talk about this at a high level, but until it's announced at law as to exactly how this can be calculated, I'm not going to speculate. I will do more research on whether how revenue can be calculated from accounting purpose. But my understanding is it uses what was in your BAS last year for the same quarter versus this quarter. So you'd be looking at a like for like. Hopefully that answers it. This isn't a question, but it's a comment. It is impossible to reach the banks. Yes, it really is impossible to reach the banks. As a mortgage customer, you should be able to ask for relief via a click on your in your online banking. There should be somewhere available to you, and likewise for most businesses there should be as well. But leaving that aside, you can still go into some branches, I believe, or suffer the pain of call centres. So I don't have a solution to that other than just keep trying and try and see what you can access online. Has there been any government directions of franchise fees in respect of franchisees or a grant to a franchisor? No. Franchisors are being treated like any other business. So again, being required to demonstrate a downturn in business to access JobKeeper, and in terms of the other grants and PAYG or whatever the other measures are, they're treated like any other business. In terms of the charging of franchise fees during this time and what's expected of a franchisor, there's been no real guidance on that, but I would expect that putting a reasonable hat on, the government would encourage franchisors and franchisees to work together collaboratively if possible. It may not be possible with large networks, to look at the impact on the franchise network and what's reasonable in terms of the charging of fees during this time. So I think there's very few franchisors that are charging 100% of fees where a franchise network is completely not trading. I think that would be not possible, but where there has been impact to trade, we are seeing amongst our franchise systems, most franchisors offering some sort of reduction in fees to assist franchisees through this time. And certainly where they are closed completely due to government order, a relaxing of some portion of fees and a move to offering alternative revenue models where possible. So there's no specific guidance other than sort of a conciliation approach and being reasonable. What is the discussion around the JobKeeper process and startups? So the discussion has been to date that where you are a startup that wasn't around this time last year, that you should still be eligible, and the minister will have discretion to assist with applying JobKeeper to your business, where you can demonstrate that you were a business that was trading, that has employees. And I think, so if you've been trading for 6 months, I think if you can demonstrate that, then there should be discretion available to the minister, commissioner, to allow a payment. But we don't know exactly what that eligibility will look like yet, or how that discretion will be exercised. We just don't know. But we do know that they are very well aware of startups. They are aware of businesses with wobbly or different or fluctuating income, and they are aware of businesses that have had mergers, acquisitions, divestments, whatever it might be during this 12 months that have drastically affected their business. How should we respond to our difficult landlord that is not being understanding and has warned us that our lease agreement has been terminated just, not just? Okay, so there will be some landlords that simply just don't care and don't engage and don't try and do the right thing. That's really disappointing because that's not what's expected. At the same time, a landlord is in business to make money, just like every other business. So on the one hand, it is understandable that they would like the lease to be complied with, but provided you can show to your landlord that you are severely impacted by COVID-19, you can demonstrate that loss. You can show them what you're doing to try and mitigate that impact, and you can put that in writing and to them with a reasonable request for assistance, whether it's abatement or deferral, and that request must be reasonable, and they ignore you, then I find it highly unlikely that they will be able to terminate your lease or evict you. And in fact, they should not be, given the moratorium on evictions. So practically, how do you actually stop them doing that when they won't engage with you, do everything you can. And if you can't, then you'll probably have to engage with a lawyer. If they try and kick you out, then you're probably going to have to get some sort of legal action to stop that happening. But certainly if you've done what you should do and what you're required to do at this time, and your financial difficulty is due to COVID and not a historical rental arrears or problem that's pre-existing, then I think you will be in a strong position, but you might need help to enforce that position, because unfortunately some human beings just aren't reasonable. Yes, for employees who earn less than $1,500 a fortnight, if you want to get the JobKeeper, then they have to be paid up to $1,500. Do I have to back pay that? Good question. I suspect the answer is yes. I think that that's what they should be on that regular salary, if that's what you want them to receive. So it'll be what they were earning as at March 1. And if that's not possible, then again, we just need to look at whether there's another way around that, whether you start it from now and try and see if that gets you through. But it may be that they require you to make a back payment. But I mean, put them on $1,500 now and see how you go. But if not, you might be required to back pay. I don't think that's been specifically addressed by the government at this point in time. Good question. Is annual leave and normal leave, sick leave, etc., accruing when employees are being paid but not working any hours at all? I don't know that that's been answered, and I haven't seen that answered anywhere. If they're not doing anything, it's interesting because they're still being paid a wage and it's still counting for service. So probably is the answer, because I would suspect that at the end of the day, you're still making a payment for an employee and you're still being reimbursed for that payment. The fact that you may not have any work for them to do remotely or in another capacity is unfortunate, but I would assume it does. But again, I'm happy to be proven wrong on that, but I've not seen that answered anywhere. But I would assume it does. I think the prudent approach is to assume yes, and if not, then great, adjust back for it. For casual employees, if they were originally employed more than 12 months ago, however, took an extended leave and recommenced before 1 March, are they eligible to receive JobKeeper? Depends on what basis were they on extended leave. If it was just kind of a sporadic working from time to time, or if they were periodically absent for a full 12 months and only just came back on 1 March, I think you could argue that they weren't ticking the box of a 12-month employed worker. The idea being, for the casual front, it's to capture workers who have systematic regular work with an employer over a long period of time, so a period of 12 months or more. It's not designed to catch people that work a couple of hours a week here and then you never see them again, or the seasonal workforce over Christmas. That's not what it's about. So for someone who's been absent for a year or more and then just comes back just before 1 March, I would say probably not. Again, but if that employee tells you that they expect to be counted, then I think you should contact the government and try and get clarity on that. Don't exclude them without checking first, but certainly from a practical perspective, I would think that's not what is intended to be captured. I can claim the 50% rebate for my apprentice's wage. However, if I claim JobKeeper, she would get paid more. Am I reading it right? I just claim that and not the apprenticeship rate, that she'll be getting paid more. So, interesting one. The answer to that is that it's not intended that you claim one and then the other, so you can't double dip. So what I would expect you to do is claim the one that gives you the most. So you're not intended to claim both and double dip. You're supposed to claim one and not the other. So claim the one that gives you the most is a simple answer. I think I've got most of these questions. Look, I think I've hopefully answered most of your questions, and most of you have dropped, all the numbers have dropped down now, so I assume people have hopefully got something out of this. If you haven't, email me, olivia@hitchadvisory.com. I will post these slides onto our website later, and you can access this on YouTube also later. But definitely email me, olivia@hitchadvisory.com or hello@hitchadvisory.com. And any specific questions that you've answered that we've been a bit vague on or don't really know yet, we can get back to you that way. Or if you need help with anything, give us a shout out. But thanks for joining, and please take care, and hopefully business is kind to you during this time. Thanks, everyone.